Okay. Assalamu alaikum and welcome to the third workshop for Community Companions. I'm your host and project coordinator, Zebanissa Rao, and I'm pleased to meet you all here today. My co-host today is Farzana Siddiqui. Assalamu alaikum.
Alaikum assalam. Thank you so much.
Sister Farzana is a trained counselor and member of our team. And we also have Uzma Sayed. Assalamu alaikum.
Wa alaikum assalam.
Uzma is a lawyer and also a member of our team. By now, you would be aware of Community Companions, which is a project of Hounslow Muslim Center designed to support the elderly and vulnerable in our community. You will find in the chat room contact details for the project. Today is the third workshop in a series to help engage and empower the elders in our community in matters related to medicine, mental health, hobbies, and social activities. Our guest today is Farah Khan. Assalamu alaikum.
Wa alaikum assalam, rahmatullah.
Sister Farah studied maths at Oxford University. She later did postgraduate studies and qualified as a solicitor, working as a city lawyer. She now works at iWills Solicitors and specializes in Islamic wills, powers of attorney, trusts, inheritance, tax planning, probate, and charities. Farah is also a management committee member of the women's organization Liaise. Today's topic is taking care of your legal necessities, come what may in life. Research by an insurance company, Royal London, shows that 54% of UK adults do not have a will and 5.4 million people do not know how to make one. Most of us do not even understand the importance of making one. As food for thought, a will is the only legal way to specify how you would want your child cared for if you die before they turn 18. Yet we think of wills as only important for the elderly. By attending this workshop, you can learn more about this crucial legal requirement, protect yourselves and your families, and educate others. And to guide us through this, I welcome and hand over to our speaker, Farah.
Thank you, Zebanissa. I'm just going to share my screen. Okay. Right, so thank you, Zebanissa, for that. And you very correctly have identified just the need, that very need for looking at what we need to do in taking care of the legal necessities that apply to us and which are our responsibility. So we've taken the topic of taking care of your legal necessities, and they can be many depending on your own circumstances, but we've picked a few, and I think wills certainly features there right at the top. And there's a few others, and again, I would like to look at them and see if they can be useful, relevant, and therefore people should take steps to implement whatever needs to be done. So the first one, as you said, a will. Now, I've written tax efficient, and I'll explain the bracketed word as well. But why do we need a will? Well, most people think, I've told my family what I want, why do I need a will? And we'll look at exactly why that's not the right attitude to take. The other sort of areas I've identified, which may be applicable to certain people, maybe not to everybody, but certainly worth considering, is inheritance tax planning, which this is a tax at 40%, it's one of the highest percentage taxes, which can be applicable to estates literally just above the value of £325,000, which is not very high at all. And unless you plan and mitigate, you could end up with your family after you having a large inheritance tax bill. And trusts come into part of the mitigation of inheritance tax. Powers of attorney, they can be very useful, especially for the elderly. If a person is not being able to do as much as they want to in terms of dealing with their affairs, then they can nominate certain trusted individuals to act on their behalf, and we'll look at that. And finally, I've just said deeds. Any lawyer will balk at that because deeds could mean anything. But I've got a few examples, and it's a way to consider legalizing or making sure that a correct record is kept of certain, usually matters relating to property, assets, and finance, but so that there's an accurate record. Okay, so a tax efficient will. And I think it's important to say tax efficient, and I'll explain why. So 8 reasons that everybody should at least consider a will. So what happens when you say that I've just told my family they know what I want, so it's all fine? Well, if someone passes away without a will, no matter what the family says, the intestacy rules come into play. Now, these are statutory rules, and they're standardized. So they are not necessarily taking into account tax efficiency or your faith requirements. They are just there to try and divide up an estate as best as possible. And under intestacy rules, the bulk goes to a spouse, but it doesn't take into account other close relationships, or indeed if someone else may have more need. And if there isn't a spouse, then they tend to go all to children. Again, no account is taken off the maturity of the children or their personal circumstances. At age 18, they become absolutely entitled to whatever share is theirs. So it's not one that we should willingly put ourselves under. We should consider intestacy rules as something which are a complete last resort, rather than something which we're happy to subject our family to after our death. Excuse me. So tax efficiency is something I've put in the title because actually intestacy rules, well, they are, if you have a very small estate, you might think, I don't need a will. And that's fair enough. You know, you can, if it's below the £325,000 threshold, chances are, even under the intestacy rules, with all the inconvenience and the extra cost of having to apply for probate, as opposed to if you have a will, it will still pretty much give the shares to the right people. But if there's anything above that threshold, which is quite a low one given today's house prices, etc., then tax efficiency is not something the intestacy rules have taken into account. And that's something which your own will can therefore provide for. And that can be with many different sort of legal tools. You can use trusts, or you can also make sure that you use all the exemptions which are out there. And the largest exemption is actually for a spouse. This can also, again, be relevant because the spouse is one where the marriage is legally recognized under English law. So we need to consider whether it's been, whether it is that kind of marriage, or if it's under a nikah in England, then that it's been registered. Guardians, and in fact, Vanessa, you picked the most important thing, which people seem not to consider at all. You don't need to consider a will unless you have assets and or dependents. And the dependents, I would argue, are the more important. If you've got young children, and you know, otherwise there is no way to specify not only who the guardians should be, but also any other wishes that you might have in terms of their upbringing. So really, any parent with children must have a will. Executors and trustees, again, these are terms which are used interchangeably sometimes, but really executors deal with your, if a person's passed away, the people who deal with the right at the outset, dealing with all their affairs, calling in assets, paying off debts, applying for probate, dealing with the authorities and figuring out whether there is any tax to pay. Those are the executors. If there is a will, hopefully the person had a will in place and it set up a trust of some sort, then the executors will pass over whatever needs to go into the trust. And they usually, the same people then take on the role of trustees. So yet again, unless you have a will which specifies who you want those people to be, you won't be able to be sure that those are the people who will be dealing with your affairs after your death. Okay. The next few, sort of asset protection, it sounds a bit fancy, but actually all it means is, again, that if you consider that a child, as soon as they turn 18, could become entitled to a large, you know, either a property or a large amount of money under the intestacy rules, there is a definite risk to the assets in their control. They themselves could be vulnerable, they could be exploited by others, or they just may not be mature enough. So again, if you wish to have assets protected, your will can do all that. A will is just so much more of a document than we give it credit for. Funeral wishes, of course, you know, it's something personal. You can give your preferences, and if you have religious requirements, those can be put in there. You would hope that the community has sort of procedures in place where funeral requirements, the rights, would be fulfilled anyway. But these could be specific wishes, and especially for people where there might be a disagreement between the surviving members, for example, of wishing to repatriate someone's body to another country and have it buried there, or being buried just, you know, in the closest Muslim cemetery in the country where you pass away. So asset protection, funeral wishes, and charity. Now we all, alhamdulillah, give to charity as much as we can during our lives. We do the best we can. But when we pass away, it's a unique opportunity to give actually a larger amount, and also an amount which could be used as an ongoing, endowment charitable giving, which according to some faiths, again, it means that you get ongoing good deeds, and also the effect of it is much longer lasting. And finally, I've alluded to it before, compliance with faith requirements. So if you don't have a will, the intestacy rules certainly don't comply with, they don't take into account any of the requirements under any of the faiths. So your will can do that if you have one in place. Now I've put in this inverted commas testamentary capacity. It's not necessarily a phrase we use every day, but essentially all it means is that a person considering making a will needs to have it's a legally described mental ability to be able to make their will. And if that's actually a good reason why we shouldn't delay making our wills. We should make them when we're well and healthy, and not see it as something which is an end of life action to be done. The later we leave it, the more testamentary capacity can come into question, and then certain certain hurdles have to be jumped over in order to ensure that a will wouldn't be challenged on the basis that the person making it didn't have the testamentary capacity. So again, that it's very much dependent on each case, and an individual can be assessed. And it's a low threshold because the understanding is that you would want most people to be able to make a will, but certainly it shouldn't be, if it's at all something which can be called into question, there should be records noting how it has been tested and deemed to be sufficient. So that's wills. We can come back to them with more questions. Obviously, I didn't go into great detail, but I've given you a flavour of the kind of issues which need to be considered when making a will. And as you can see, it's far greater than just who will get my money. Right. The next sort of area which I thought could be relevant to some people is this idea of IHT planning, inheritance tax planning, and it can certainly save you money in the long run. Tax is not anybody's favorite, well, some people's favorite topic, but not everybody's favorite topic. But if we live in this country, in any country, we should know the laws which will apply to us. You know, each one of us is going to pass away. Whatever we have is going to be subject to the tax regime. And so certain things are very important to know. So the first thing is a nil rate band. That's currently at £325,000 per person. And that means that's the amount that you can leave as gifts to your family, and there's no inheritance tax payable. There is an additional residence nil rate band. This has only come in the last few years, and it's to do with people who own a property, because property prices went up very quickly, and most estates were otherwise above the £325,000 threshold. So the government introduced the residence nil rate ban. There are certain conditions attached to this residence nil rate band, and it's only up to an extra £175,000 per person. So as long as the conditions are met, which briefly, it's if you've owned a property which you've lived in as a home, and it's passing to children or grandchildren, and the total estate is below a certain threshold, then there's this additional amount that can be left to family, to other beneficiaries without inheritance tax coming in. And lifetime gifts, people obviously often give lifetime gifts of either money or even property. And that's a good way to keep your estate below the thresholds, the residence no rate band and the IHT no rate band. But if a person passes away within a certain number of years of making a gift, then that would still be counted within their nil rate band. It would be treated as if it was part of their estate for the inheritance tax calculation. So in order to plan for tax and mitigate it as best as possible, you need to look at the tools which are available. These do include trusts, but we take a comprehensive approach because really it ties in with wills as well. So the tax planning in your lifetime is therefore linked to your wills in order to make it all come together when you pass away, in order to avoid unnecessary tax. Okay, so that's a bit of that. Powers of attorney are actually very important, and in fact, I'll talk a little bit more about why I think we should all consider them. Certainly, I have put one in place now, and my husband has. So, what are they? Once again, the capacity to grant a power of attorney is something that is considered at the time of making a grant. Again, best to do it before it's needed. So there are many types of power of attorney. First one is where you just give a limited authority. So, for example, just for a particular transaction. So for a sale of a property where a person can't get there physically, or they're unwell, or it's in another country and they don't want to travel there to complete the formalities, they can give a very limited power of attorney to an individual who they trust, and it's restricted in time and scope. But the next one is the one which I really want people to consider. It's called the lasting power of attorney, an LPA. And the reason why it's called lasting is because it lasts beyond a person losing mental capacity. So the person giving it is called the grantor. A grantor grants a power of attorney. If they make a lasting power of attorney, they're essentially choosing someone, one or more people that they trust, to make decisions for them if they were to lose their own mental capacity. And because this is quite significant, it's quite a powerful sort of authority to give to someone else to deal with your affairs in your stead. This is overseen by the Office of the Public Guardian. And the Office of the Public Guardian has broken down the LPAs into two areas. That you have your property and financial affairs LPA, which, as it says, is more to do with financial matters and assets that you own, in terms of selling them, dealing with them, accessing bank accounts. But there's also a personal welfare LPA, and that's to do with health, medical treatment, where someone may need to live, for example, if they've lost their own mental capacity or they don't have full capacity to understand what they might require. If you haven't granted someone else the authority to make those decisions for you, those decisions will actually be made either by medical staff by application to the court. And again, not only does that bring in the court, who is obviously not privy to all your personal situation and your personal wishes, and also the process brings in cost because you end up having to engage lawyers to help you with it. Now, both these LPAs are significant. They should be considered very seriously because essentially you are giving someone else power to deal with your affairs. But because they are quite so far-reaching, they have quite lengthy application forms which allow you to put in quite a lot of safeguards. So, for example, you could give the authority only if you were to lose your mental capacity. And in case of the personal welfare, that would only be the case that someone else can make decisions for you if you are no longer able to, with all practical steps taken to help you make those decisions. So the forms allow you to choose one or more person. You can specify whether you'd like, say, if you had two attorneys, whether you would want them to always make decisions jointly. That can be useful because it means both people have an equal input into a decision on your behalf. But it could also mean that if one of them is unavailable or unwell or traveling, for example, then the decisions couldn't be made. So an alternative that you could specify instead is that you allow your attorneys to make decisions jointly and severally. So essentially they can act together, but each one can also act unilaterally. So it means that if something has to be decided in a hurry, we've had personal welfare LPAs had to be used where someone is unwell, and then an intervention is required, which becomes a life-saving treatment if it's not done immediately, and consent is needed. And if they haven't got their own mental capacity to give an informed consent, then an attorney is the ideal person, because it should be someone who's fully aware of your wishes. And again, you can put your wishes into, have them recorded in the granting of the LPA itself anyway. So it's something to consider. We don't want to think about it, but most of these sort of steps that we would take are in order to be used in a time, of difficulty. Hopefully we're not put in that situation, but if we are, then at least we've made provision for that situation. Registration is required for both these LPAs. As I say, it's seen as quite a significant granting of permission to someone else to deal with your affairs. So it needs to be registered at the Office of the Public Guardian. Yet again, if it's done sooner, the better, because if it is sent for registration, if the form, the application form is sent for registration when someone has already lost capacity and there is some difficulty, some error in the form, then they won't have the capacity to grant. They won't be able to re-grant the form and re-sign all the paperwork, which means that the LPA would not be registered, in which case it can't be used. So these are the safeguards that the Office of the Public Guardian wants to put in place, but it means that we need to have been conscious and made an intention to consider whether these are steps that we need to take early on in our life. And the reason I come to this, the last point of avoiding a court of protection application, this is what has actually prompted myself and my husband to grant LPAs to each other, because there are times, and unfortunately we come across several of these, where a family, a loved one in a family can suddenly lose the mental capacity to deal with their affairs. This can be sudden, from God forbid an accident or an illness, or it can come on gradually. So you can imagine while the family is dealing with this really difficult situation and trying to provide the care required by the person's called a patient in legal terms, because they are now requiring care. While the family is struggling with that, they could also find themselves in the situation where they don't have access to vital funds. They can't access the funds of the patient themselves. If there was an LPA, a Property and Financial Affairs LPA, then the attorney would be able to step in and make decisions of how to use the funds. But in the absence of the patient having granted someone a lasting power of attorney, the only real option would be to apply to the Court of Protection. And as I've mentioned before, that means once again the cost and the time taken to make the application, the fact that the Court of Protection is not aware of a person's personal circumstances and preferences. So it can be quite a distressing process in itself. And sadly, one which often, despite its good intentions, the very rigid rules can cause a lot of hardship for the families of the patient themselves. So one to try and avoid. So that's powers of attorney. And finally, deeds. To make things clear, as I say, deeds can be used for numerous situations, but here are some examples where you might think, oh, actually, that could be useful, that could solve that problem, rather than just relying on one or more individuals knowing some information. It can actually be recorded, excuse me, be signed and witnessed, which means that if there is a problem further down the line, the deed can actually be produced in court even, or in legal proceedings. So, for example, if there's joint property ownership where the ownership is not equal, you can have a deed which records what the actual ownership should be, potentially giving reasons for why. So if there's a challenge in court to someone having more ownership or more than 50%, the reasons have been recorded. and both parties have signed it and there were witnesses, which means, again, it carries more legal weight. A trust deed, a declaration of trust, this is interesting because it comes up more often than we realize when people say, well, this property or this home is in someone's name legally, but actually it belongs to everybody. Well, that's fine as long as all the parties are in agreement and, God forbid, nobody's going to have a bad intention at some point, or even for, quite genuine reasons of being in need. But a declaration of trust can record that, the fact that one person is holding property for several others and that it's not just for their own benefit. And it can also ensure that the correct proportions are recorded. You can also have a declaration of trust for a right to occupy. So, for example, under the Islamic faith, spouses don't get a very large amount. They certainly don't get the whole of the estate of someone who's passed away, which can mean that they can be left in a precarious position about a security of home because they're not entitled to all of the home. Well, again, you could have a declaration of trust deed, which records that you've granted a right to occupy to your surviving spouse. And again, that safeguards them from a legal point of view, and we don't then have all these unfortunate stories where we hear that grown adult children are forcing an elderly parent to sell so that they can take their inheritance share. So there's a lot to do with assets, and it's as we have acquired wealth and society has changed where we do hold a lot of property and money, how we want that to pass on after our own lives have ended. There's so much that can go wrong, and there's so much we can do to at least do our best to avoid those pitfalls. And there are many other agreements as well, but as I say, it really depends on what the person's circumstances are. Right, I've spoken for quite a while, so I will stop there and see if, first of all, if any questions came out of what I've discussed already. I'll stop sharing the screen for now. And then we can discuss some sort of more specific situations that anybody might have.
Can I ask? Thank you so much, Farah Khan, for a very detailed explanation of all the things. I just wanted to clarify this, that inheritance tax planning, nil rate ban, 325,000. What do you mean by that, please? If you can explain more in detail.
Yes. So when we die, we own assets, and they all make up our estate.
I see.
And when we are leaving that to other people, so we're passing it on under inheritance, there's actually a tax attached to that because HMRC is with us, it's as our enduring partner throughout life. So even when we're passing away, they want to take view of our assets and say, well, okay, you've enjoyed the benefit of these assets over your life. There is a tax to pay on them. But they have allowed a certain amount to pass without any tax being paid. So it's like a personal allowance in income tax. So your personal allowance for when you die is that inheritance nil rate band. So £325,000, each individual can leave that amount, that value of assets or money or shares, whatever it may be,
in the house
to their family without any inheritance tax being payable on that.
And the house?
Even the house will come into that. So most homes, the average price, I think, of a home now is close to 300,000, I believe. So you can see that some estates will be within the nil rate band, so there's no issue of inheritance tax, but a very large number will now be above the inheritance tax threshold. Because if you take into account everything a person owns, they may own a whole house or half a house, say with a partner or a spouse, and then they will have other assets that they own, property, other property, funds, jewelry, if they buy shares, anything else really, cars, anything which has a value. And all that is calculated and put together as the sum on which inheritance tax is calculated. So the first £325,000 is fine, it's exempt. Then anything above that would be charged at 40%.
I was told that it's 700,000? No.
So that people tend to talk about a married couple. I mean, obviously that doesn't apply to everybody, but it's certainly not 700,000. If you look at a married couple's allowance, then as I say, there's a lot of structures you can put into a will. And one is to give a life interest to a spouse, which means that for tax purposes, you're not using up any of your own nil rate band, because anything which passes between spouses is exempt from all tax. And if it's completely unused, your nil rate band, then when the second of the couple passes away, the trustees, the executors can actually apply for the first person who died their unused nil rate band. So you could amalgamate the two lots of £325,000, and that would give you up to £650,000 then.
Thank you so much. Thank you.
So anything above that then is chargeable to tax at 40%, and that's what your executors have to deal with. That's one of their main roles is evaluating all your assets. They have to fill in a form which informs the tax authorities what your assets are and who they're passing to, in case they're passed to an exempt beneficiary, and what tax is payable, and then they have to pay the tax. So HMRC doesn't let go until the tax is done, then they step back and the distribution can actually be made to your inheritors.
Thank you so much for explaining in detail. Thank you.
And thank you for a very informative presentation, and a lot of deep understanding has happened after this. We can open the floor to questions from the attendees as well. If you could turn on your video, introduce yourself and ask any questions that you might have. If for some reason you cannot, then you can send the questions via the chat room. Until then, I do have a query actually that I think I mentioned this to you before, Farah, that if there's a situation where there's, in my mind, there's a widow who has the mortgage to the house paid off, has some kind of mental health issues. I doubt whether she has power of attorney in place, and she doesn't have the deeds to her home. So what can be done to help her in that situation?
Nowadays, the first place to check, luckily a lot of things have been digitalized and the records are online. If she can look up at Land Registry the details of her own home. There's a small fee payable, or you can go through a solicitor who can do it for you as well, but it's something which can be accessed. Now, the only reason a property wouldn't be at Land Registry and have all its the documents and title deeds available there is if it hasn't changed hands, if it hasn't changed ownership for a very many number of years. So we're talking probably 30 plus years. So then there is a likelihood that it was never registered at all. So first registration needed to have happened at some transaction when ownership changed. But generally, the vast majority of properties are now registered at Land Registry, and they can be looked up. The details can be looked up, just like you can look up a company at Companies House. These are now deeds which are online. So that would be the first thing to do, because that gives you the ability to check, well, whose name is actually on the legal title deeds, who is the legal owner of this home. And, you know, it could just be that simple steps are needed to be taken to ensure that it's now actually in the name of the elderly person themselves and only in their names, and that there is no sort of remnants of other previous owners, perhaps a spouse whose name is still there. And you can also check the way in which, there are many ways in which you can hold property. You can ascertain that as well from checking the Land Registry deeds.
You mentioned what happens in cases of intestacy, but I mean, so what happens if someone loses capacity and does not have an LPA in place?
Yeah. So the thing to separate is that wills are when someone passes away, and the intestacy rules will come in only at that point. The powers of attorney are for when the person is alive and just cannot deal with their own affairs. So you can see, I mean, when a lasting power of attorney is meant to last you through perhaps losing capacity. Once the person passes away, then the power of attorney obviously lapses, and the will comes into place, and the people who've been appointed as executors and trustees then become the ones who actually have control of all the affairs. But the lasting power of attorney, I think, is just something which is either their awareness of it is not high enough, or it's underplayed. People think, oh, power of attorneys are either for very rich people or for very old people. And, you know, my experience has been such that I've realized that if we all gave it a bit more attention and gave it the time it needed, you know, when we have full capacity, then we don't actually go into that place where we're losing capacity. Yet there's nobody who's been authorized by ourselves, our own choosing, to be able to make decisions for us. And you then get to the point where I think you end up having elderly people, perhaps their wishes being overridden by others who think they know better.
Okay, so another question is, can someone just tell their family their wishes and not bother with making a formal will?
Now, ideally, you would think that's a good idea, isn't it? I think that's the minimum you need to do. You need, if all is well in the family and there's a good family relationship between people, communication is ideal. And even when you're making your will, it's best to have communicated if you've given sort of a large amount to charity or you want to benefit someone else, because essentially the shock of someone passing and dealing with that is difficult enough. But if you open up a will and, very unexpected things are in there, that can cause further problems in the family. However, the question that you've said, even though it's fine that you can say, well, everybody in the family knows what I want, they are still going to be at the mercy of the authorities here. So if they need probate, which means that they need a formal authority to deal with anything which is in someone else's name, so apart from, say, if a person passed away, only had some bank accounts with less than £10,000 in each, the banks are usually, although they all have their own procedures, they're likely to say, if you can show us a death certificate and you can show us that you're the next of kin, so what your relationship is to the deceased person, we can release the figure, the balance to you. They'll take an indemnity from you saying that, in case you're the wrong person and someone else is entitled to this money, the bank doesn't want to be held responsible. They have a legal right to recover the money from you. That's one of the few cases when you don't need a will at all. If anybody has passed away and they own assets, that's when you don't need probate. If anybody has passed away and they have owned assets, you do need to apply for probate, which is that formal permission to deal with anybody else. Just like, when you have an account with British Gas and you call and it's in your husband's name, or, the husband calls and it's in the wife's name, you have to come online and say, yes, I give permission for you to speak to this other person. It's literally like that. So the intestacy rules, which they are there to safeguard people, but it makes it a much harder process to go and get probate and prove who you are and why you should be given probate, and then get the permission to deal with it. So for the sake of, if you've already told your family what your wishes are, then writing it down really shouldn't be a step that's missed out, because it will just make life harder for the family afterwards if they're having to, by having that piece of paper signed and witnessed by the person who's passed away, the path is much easier.
Absolutely.
But also orally, under English law, a will has to be in writing anyway. So you can't assume that will act as a will that you've told someone your wishes.
Okay. Another question, if someone has made a will with a mainstream lawyer, so general British law, is it necessary to convert it to an Islamic will? And is there much difference between the two? For a Muslim, obviously, this is.
Yes, and in fact, I will probably go back to sharing if you don't mind. I've got one extra slide because, so just to say that there is no such thing as an Islamic will and an English will, and people should be clear that an Islamic will must be valid under English law. So it's a valid English will, but under English law, you can leave your estate to anybody. There is no requirements. People have left it all to charity. There's some famous cases where people have left it all to charity deliberately to deprive, a wayward child of their inheritance. So what we can do is to say we make a will, which is valid under English law, but we specify that we want the distribution to be in accordance with the Sharia or the faith requirements. And they are quite different. So if I just go back to sharing for a moment, if I'm still able to, and just share the next slide, because there's quite a lot there. Just go on. So there was enough to actually make a separate slide, and I felt that if the question came up, then really it's worth considering it in a bit more detail. So you would have a normal English will, but what are the extra considerations that you need to take into account if you're looking at making it Sharia compliant? So in accordance with very clear directions in Surah An-Nisa, and also through development of the fiqh by scholars. So as we probably all know, that there are certain prescribed shares. So the inheritance, according to Islam, can always be figured out. The shares can always be figured out depending on which family members have survived a certain person who's passed away. So the permutations are all different. So if there's no if there are no parents, then the shares are going to be different. If there's no spouse, the shares are going to be different. And depending on who has survived, they will all have a certain share. Sorry, not all, but within it, the Islamic inheritance laws start from those closest to you. So it's parents, spouse, and children. And then if any of those categories doesn't have anybody in them, then it can pass to further, more distant relatives. So there is always, the shares are always something that can be calculated. And in fact, we have an app. If anybody's interested, I can just share that at the end as well. But you can always figure out who will get what share, depending on who survives the deceased person. Now, you'll recall that I talked about this spouse exemption, that if you pass everything to a spouse under English law, there's no inheritance tax. Well, under Islamic law, as you probably know, the spouses don't get the bulk of the estate. So if there is a husband and wife, if the husband passes away and there are children, then the wife gets 1/8 of his estate. Conversely, if there's a wife and there are children in their situation, and she passes away, her husband will get 1/4. So that could be a situation where most of the estate is going to non-exempt beneficiaries for whom inheritance tax will need to be calculated, subject to the nil rate bans. So there are ways of making the Islamic will tax efficient so that we don't lose all the exemptions that exist if we were to leave everything to spouse. But we do that in a way which is still Sharia compliant. And that can be through life interest trusts generally. And similarly, just like the spouse won't be taking the bulk of the estate, that could also mean that they don't then have security of home anymore. So again, similarly to what we said before about the life interest trust to a spouse to allow them to still have a right, for example, to live in a home, even if they only own 1/8 of their husband's share or 1/4 of their wife's share. That would be, you could again make provision for that within the Islamic will. So the Islamic will, it starts with the prescribed shares, and then because of the implications and the consequences, we end up having to put in other structures. Guardianship rights, again, whether a couple are divorced or not, Islam has some things to say about guardianship, and the being able to specify who the most appropriate person would be in that unfortunate circumstance where a child under 18 is left without parents. Utilizing the 1/3 wasiya. Now it's interesting because we usually use in Urdu, especially the word wasiya to mean the will. But that's actually not the case. The wasiya, Islamically, it's understood that according to Allah, the shares have been given already. They've been specified. Allah subhanahu wa ta'ala has told you who should get what. But knowing human nature, there's an allowance to use up to a maximum of 1/3 of your total estate as the wasiya to give to people whom you wish to give to and who don't have an automatic Islamic share. So it can be to charity, for example, and it can also be to other family members who wouldn't otherwise get a share under the Islamic law. So again, that can be put in there specifically. gifting and distribution during one's life is where to take into account that if people do end up gifting larger amounts during their own lifetime to, for example, children, but they want that to be sort of taken into account as being part of their future inheritance. It's not ideal, it's not technically correct, but we all are in that situation as we live longer, that we would want to give perhaps something to our children, at a time when they're setting up in life and they have a greater need. But we may want to specify that that's taken into account as against their inheritance share. And again, that's something you can specifically put in to say, I do want the Islamic distribution, but I would like the fact that I've given this much to one child to be taken into account as part of their share that they've received already. And similarly, just these are points where under English law, jointly owned property can often just pass to the surviving owner. And that again is not the Islamic proportion. That wouldn't be the correct Islamic distribution. So you can make provision to make sure that that doesn't happen, sort of, an unintended consequence without a will. And finally, nasiha. Now this is sort of prophetic precedent, if you like, to give sincere advice and good counsel to those who are left behind after you. And again, a lot of people sort of would like to personalize what they say in their will, because in a way it's like it's the last time you speak generally to children or to other family members. And that's part of the etiquette, I guess, as well, of having an Islamic will, where you first can repeat your testimony of faith, and then you give some good advice to those left behind in terms of how they should prepare for their death. So I'll just stop sharing. Well, actually, I'll share one more thing because it's quite compelling. And you probably all may have heard of this hadith, but it says it's the duty of every Muslim who has anything to bequeath to not let even 2 nights pass without writing a will about it. And even more so, I found this hadith quite scary, if you like, that a man could do good deeds for 70 years, but if he or she a person acts unjustly when they leave this they make their will, then the wickedness of that final deed will be sealed upon them, and they gain the punishment of the fire. But if on the other hand, a person has lived a life for 70 years and not done much good, but in the last step they take in distributing their estate, they're just, then the goodness of that will be sealed upon them, and they will gain paradise. Now, I actually asked our mufti, we have a mufti who advises us to ensure that we are in accordance with Sharia when we do more complicated wills. And I said to him, this seems so rather unfair, in a way. And he said, but if you think about it, we could do good deeds for all our lives, but what we end up doing in how inheritance passes, that can have a good or bad effect for generations after us. So the good or the bad effect of it can be ongoing and multiplied in terms of bad relationships, broken families, people even leaving the faith, God forbid, in terms of what they saw was done unjustly to them. So it is actually that serious that this hadith exists, and it's a relatively strong one. So if we needed more, something to compel us to consider making a will, then this would be one of those sayings of the Prophet, peace be upon him. So I'll stop sharing again, Zebinissa, so we can come back to that. So we obviously specialize in Islamic wills, so there's a lot to say about it. But that's, again, a flavor of what you need to be considering. If you're a Muslim, it's a duty upon you. It's not something which is, it's not a choice, really.
Yeah, it's quite frightening how serious and how necessary it is. But unfortunately, many people are not really aware of this, the need and the requirement. So hopefully, this will help. We can pass the message on in terms of the Islamic will, and compared to the mainstream wills. The Islamic is, as you described, there are permutations, there are kind of rigid rules in which it goes, but there's a lot more that you can add on to it. For example, the wasiha and the 1/3 that can go to charity or anywhere that you like, and adding more information on to that too. We have a question. Assalamu alaikum. In Islam, are we allowed to write a will, or should we only follow property distribution according to Islam? And are we allowed to write in the will who should look after our children in case of our passing? So the guardian.
So, yeah, so it's we've touched on this before, but yes, I mean, what you are doing by, if you live in a country where the Sharia will be applied in any case, then you don't need to worry about writing a will. And there are countries like that. So I have friends for example, in Egypt, a friend told me that essentially when someone dies, you just get a record of what the distribution needs to be for that person based on their family members who survives them. And then they leave it up to the family to just make the distribution. You know, arguably that works there. But in a country like England, which we've made our home, we need to be aware that actually we need to know the laws of the land we live in to ensure that we are able to, you know, discharge the duties of our faith. So we need to make a will, which is valid under the laws in England, but make it so that it is in compliance with the Sharia. So absolutely right. We shouldn't start saying, you know, we now live in the West and this is a very different place, so I'm going to give equally to my kids and all that. No, I think we should find ourselves taking due care to still comply with the faith requirements. And I'm astounded at how in a book, you know, that thick, the Quran, the Holy Quran, there is so much detail given on inheritance. It's, you know, it goes on for several ayat and you think, okay, this was something Allah could have left as nuance, could have left it, you know, in many ways could have just alluded to it. But Allah subhanahu wa ta'ala has made it so clear that you can take any situation, any kind of combination of family members who are left, and you can figure out what the distribution should be. So yes, you need a will. It must be written down, but to say that you wish to comply with the faith requirements. And yes, the guardians as well, exactly that, because otherwise you're leaving it. There are systems in place in the country which are there to safeguard, but social, as you know, as we know, social services and public bodies, they're not the best place to make judgments on who should care for children, especially if there's mental health conditions or a child might be unwell, or, you know, certain requirements in terms of their own faith upbringing as well. So you should definitely, I think if you've got children, guardians is one of the most important things that you can specify in your will.
And I mean, Islamically, there's a kind of a ruling of who the guardianship falls onto when the parents have passed. So is that something that you should write in your will, or can you just opt for that this is the Sharia law that we want to go with?
Interestingly, guardianship, the rules on guardianship there are varied opinions, and it often says that it should be the person who would be the best in terms of for the child's life in this world and life in the hereafter. Yeah. So there's a lot more left to, there's nobody specified. It's not like it has to be someone. There is that leeway given as to who will be the best person to bring up this child within the faith, within Islam. So that's something actually that, you know, only parents can figure it out at this point, that if something were to happen to both of them. And under English law, you know, if there is a parent, they have got parental responsibility. So you could have, you know, parents who are separated, for example, and one of them doesn't follow the faith at all, or is, you know, does things which are in opposition to the faith. And yet under English law, they would have parental responsibility still if one parent passed away. Now, if you specify in your will that actually you understand they have parental responsibility, but these are the reasons why you've nominated someone else as a guardian, then actually you've made the case for other people, for example, your executors, to say, well, if the public bodies are getting involved, that this person has parental responsibility, to take into account the wishes of the other parent who's now passed away. So that is the only chance you have of, you know, influencing that. So we sometimes have clients who write very long guardianship clauses because they say that although these are close relatives, we do not wish them to be involved in the children's, you know, moral upbringing, for example, because they have their reasons because of the situation. And that's something you can specify then. And your executors are there, and the trustees are there to try and help to ensure that that is what happens.
And just, you must have mentioned it before, but just to clarify, that if a person passes away, without leaving a will, and they wanted the inheritance to go, obviously, according to Sharia, according to Islamic law. How, I mean, this is very pertinent for situations where there are people who have converted to Islam. And obviously their family would want them to be buried and the inheritance to go according to the British law. So how is it possible to say that, no, we know that this person would have liked to have the Islamic ruling, and how do you do that?
Without a will, it's actually very difficult. And thankfully, many years ago, but we know of someone who was who had become Muslim but was cremated because the family was not Muslim, and you know, only friends were Muslim, and they didn't hold any sway over what the family was saying, and that was what the family's choice was, and it wouldn't have been theirs. And that's the extreme, if you like, circumstance, and hopefully that would never happen. As I say now, I hope our community is mature enough, you know, with sort of the initiatives like you're running yourself, to know who the people are. They might be Muslims who are alone and are converts, and nobody knows about the fact that they're Muslim. So, you know, who would be in place, who would be in the best position to say, well, their affairs need to be dealt with in accordance with their faith. Nobody is there to you know, make that. I mean, just recently, locally, we've because of the mosque community, we know of someone who had converted many years ago, and they were now very elderly in a nursing home, and nobody knew of their faith, and they were now asking for someone to come and make a record of what they wanted to do, and it was quite difficult because of capacity issues as well. But certainly without a will, a convert is leaving their affairs in the hands of others who may not even know. It might not necessarily be going against their wishes, but they might not know of their wishes. So I think it's important actually for converts to consider this as well, and make it clear what their wishes are.
And if it's a Muslim person who's passed away, then do the wishes, I mean, the advice of the family, if they put it forward that this is what they would have liked, would that matter? You
can. I mean, yes, it's certainly people who are around after someone's passed away, they can do their best to implement the correct distribution according to the faith, but they might face opposition. So for example, if someone else can rely on the law of intestacy, then it's going to be difficult to make a case to say, but we know this person is Muslim and would have wanted this, if it's not written down. But yes, as a community, if we know of someone who's passed away and there is no will, we should do our utmost to ensure that the distribution that would have happened, you know, that ought to happen from their estate, is still implemented. But you could end up facing opposition, especially from people who may then be losing out.
Absolutely. Another question has come up. At what stage do other members, like uncles, aunties, are allowed to take inheritance under Islamic Sharia, and does that happen in the UK?
So to answer the first part of the question, generally, if a person has a son or a father alive, then the only categories who have a prescribed share are children and parents, and a spouse if they have one. If you don't have a son, for example, and they're just daughters, the daughters actually get a bigger share than they would if they were sharing with a brother, but they get a fixed share, which means there's a small amount left over. If the father is alive, then that goes to the father. So yet again, if there's a father or a son, siblings, uncles, nephews, nieces, they don't get a look in. The only time more distant relatives actually get a share is if, say, there is no father and no son. That means that the women all have fixed shares, which are larger than they would have if they were sharing with a male counterpart present, so like a male in the same category as them. But once those fixed shares have been given, there's usually a small amount, like it can be something like, 3/24 or 2/12, something like that, a sixth, which gets left behind, and that tends to go to either their siblings. If there are no siblings of the deceased person, then it could go to further out people like parents, siblings, so uncles and aunts. But generally, when people say, I don't want to make a will because my daughters won't get the same share, that's not the case. You need to make a will so that you specify what the shares are. And under English law, you can do whatever you wish. So why not make an English will, and say, within this will, which is valid under English law, I wish my distribution to be according to my faith.
Another question, can you make a will on your own if you don't have big assets, or does it need to be done by solicitors? And if you could make it yourself, what is important to be in it to be accepted by law?
You can make a will by yourself. The absolute requirements are that it's signed by you in the presence of 2 witnesses who then sign in your presence. So 3 people are needed in order to have a validly signed will. If it's not validly signed, it won't be treated as a will. So, so you could have written a beautifully crafted will, and if it's not signed, it won't be taken as a will. It might be taken as an indication of your wishes, but you can see how that could be abused and exploited. So the law says if it's not executed in the correct way with the 2 witnesses, then we don't treat it as a will. If you are going to do it yourself, I would only suggest you do it if you've got virtually no assets and no young child, no child under 18. Because otherwise, I think you ought to, if you've got more assets, then you might be looking at sort of asset protection and also tax efficiency, where you might feel actually legal advice would be useful. And if you've got young children, in order to be able to provide for them, usually a trust structure is best because they can't hold property themselves anyway. And you might want to, again, take legal advice as to what does a trust structure require. That's a little bit harder for me to say, go ahead and do it yourself, but there are good templates out there. I think First Ethical, I believe they're called, do a template, but as I say, it's a template, so it's not taking into account your personal situation. But firms like us do actually do free consultations because we want people to actually think about their wills. So we do a free consultation where people can ask all the questions they have, and then it's up to them whether they go and write the will themselves or or have us write it. So I would say look for solicitors who give free consultations, so at least your questions can be answered.
Another question. Thanks for your answer. Can you please share the percentage of inheritance for family members under Islamic law, as you mentioned earlier?
Right. Let me. Because it changes depending on who is alive, you can't give a simple answer. Very basically, if you have a couple, so a married couple, with each one having their parents alive, and say they have a son and a daughter, then say the husband passes away. This is the simplest one. If the husband passes away, so we're looking at the husband's estate, 1/8 goes to his wife, 1/6 each goes to his parents, so that will be 1/3 in total. 1/3 to parents, 1/8 to wife, and the remainder goes to the children, with the son getting twice the share of the daughter. And that will use up the whole estate. Now, if it's anything more complicated, then we actually have an inheritance shares app. Can I just share a screen once more? I'm just thinking if I have it open. I'll just show it to you so you can perhaps, with your, I believe it's this one. Let me just see. No, it's not that one. Just make sure I have it open first. Yep, it's there. Right. I'll try once more. So there's it's interesting. It doesn't show when I want to share it. What I can do is I'll leave that for now. And what I can do
is the name of the app.
I can send that to you. Yes, it's an inheritance shares application, an app just that you can use on any phone. And we've actually developed it. I think it's the only one around. And it's got, not only does it allow you to put in who is alive and then figure out the shares, it also gives you a lot more information. It's got frequently asked questions. And it's really trying to give people the knowledge they have to say, yeah, I can't say anymore. I don't know how to make this will. I don't know anything about it. There's a lot of knowledge there. So Zebenis, if I perhaps send you the link for that, maybe you could share that so that everybody has access to that app.
If everyone joins the WhatsApp group for the workshops, then I can send a app directly there. But could we have the name of the app, perhaps? With that?
It's actually if you go to the App Store and search an Islamic inheritance, I think it's the first one which comes up.
Okay, that's great. We'll do that.
I did have it open, as I say, but it won't allow me, I can't seem to see the, if I can just show you what it looks like a little bit, perhaps. So it's a very low-tech way to do it, but if you can see that, can you see the yellow star, the 8-pointed star in the black? That's the actual the logo of that app, and it's literally called the Islamic Inheritance app brings it up.
Okay, all right.
And then it's free, and you can just download it. So there's a lot of information in there. So Islamic Inheritance in the app search button, and it comes up. And it's got, as I said, it's got frequently asked questions. It also explains a lot of the questions which are coming up now. We've tried to make it something which is a useful, source for people.
Okay. Just one last question, because I think we've gone over time now. Moving away from wills, this is that concerns might exist by the elderly that they might be taken advantage of by family members. How can they protect themselves from coercion or financial exploitation?
Now, sadly, this is a reality, and I think there's two parts to this question. If there's an elderly person who wants to provide for someone, but but not to be pressurized to do it in their lifetime, they should put in place the gift in the will, for example, through the 1/3 wasiya. If they're being pressurized because other people are having to do things for them, and therefore, say, for example, they're having to give a bank card to someone to go and get money, and they don't know, what that person's doing with the bank card. Again, that can be solved by having your LPA in place, so you have an attorney who you trust. But if it's actually a situation where an elderly person, a vulnerable person, is being pressurized, I would say that's more a safeguarding issue, and that's something where they need to raise the alarm, because that's more, if you like, that's almost a criminal we're wandering into that area where people are, looking after them, but using that as a means extortion to get money from them. But we as individuals need to be aware when that is a potential. So knowing the elderly people or the vulnerable people in our community is the most important. Then assisting them to put in place, if it's appropriate, to have people who they nominate, who they trust, so that you're not having to say to a carer who's just come to see you for 2 days that, can you go and get some cash out for me? Because really, you're just putting the vulnerable person is in an impossible situation. They're having to rely on someone who they haven't chosen as their trusted person. So we need to bring out where legal documents can help, but we also need to be aware if someone is in that vulnerable position where essentially it's a safeguarding risk.
Absolutely. Okay, we have actually gone over time, unfortunately, but I'd like to thank the attendees for the time and attention, and from all of us, Sister Farah, thank you for a session packed full of valuable knowledge, which we will take away and act upon, inshallah.
Alhamdulillah, it's all from Allah. I hope that whatever is useful in that is from Allah. Mistakes I have made, may Allah forgive me for them, but inshallah, I hope it's a good start.
Absolutely.
Alhamdulillah.
If you would like further legal advice, Farah is based in London and can be contacted on the details which I have listed in the chat room. I'll mention them now as well. Phone number 0203 903 6575 and email farah@iwillsolicitors.com. For anyone in difficulty and in need of advice, once lockdown eases enough to open the centre, we will soon be arranging drop-in sessions where appointments can be made to consult with Sister Farah. And please do spread the word on this. We hope you found our session today useful. And if you'd like to offer further feedback on this or suggest any workshops for the future, please get in touch via the email address mentioned. If you text your name to the phone number given, I can add you to the WhatsApp group for these workshops. And then I can also perhaps send the link to the app that Sister Farah mentioned. The email address is zebanissa@hounslow-muslimcenter.com. I think I've forgotten to add the .com at the end there. And telephone number is 07466 401 432. Thank you, Farah, for your time and expertise. And thank you, Sister Farzana and Uzma, for your participation and support. Assalamu alaikum.
Jazakallah khair. Walaikum assalam wa rahmatullah.
Thank you. It was very informative. Thank you.
you.
Thank you so much.
Yes, thank you. It was very, very good. Very
Very,
informative.
very
Alhamdulillah. Assalamu alaikum.
Alhamdulillah.
Walaikum assalam.
No.
Jazakallah khair. Jazakallah khair, Zabanisa, for
Barakallah fi. Thank you for attending
and
and supporting.
hosting such nice committee. It's very useful for all of us because in our all the time, and it has been explained very well,
Very
alhamdulillah,
well.
very well.
Mashallah, in quite in-depth detail as well.
Mashallah, mashallah. Very worthwhile, very worthwhile.
Alhamdulillah.
Alhamdulillah. Assalamu alaikum.
Walaikum assalam.
Walaikum salam.
Alaikum salam, Uzma.
Yes,
Inshallah.
inshallah. And we'll meet soon. Are you coming to